bothers me is like you see like the women screaming and like the doctor running in, and like there's this like stereotype of what, I don't know, like what we've turned birth into in cinema. And yet at the same time, it's beautiful because you're giving life. But, you know, for me and my wife, we had a beautiful experience with birth. Wow, it was also painful. I mean, my wife was in labor for, 36 hours. And so I wanted that birth scene to feel so real and beautiful.
Hi friends, it's Harry from Sister Wives Unmasked. Welcome back to the channel. I have to be honest, this case involving Blake Lively, Ryan Reynolds, and these PR agents is really wearing on me. If there's one thing I've learned through all of this, it's that some of these publicists are among the shadiest people imaginable. I can't fathom working in an industry where your literal job is to protect people like Blake, Ryan, the Duggars, or Cody Brown, people with a lot of skeletons in their closets. Let's not forget, even Leslie Sloane, one of the key players here, was Harvey Weinstein's publicist at one point. These people specialize in spinning positive narratives while burying negative ones, and Blake and Ryan have had the money and the power to keep their own stories swept under the rug for years. For the longest time, it worked like a charm. We barely saw a bad headline about them. But now the mask is slipping because court records don't lie, and the truth is starting to show. Recently, Leslie Sloane filed a motion to compel Justin Baldoni to produce documents and answer interrogatories. Now, let me break this down. This move feels very calculated and frankly premature. We're only 2 weeks out from the deadline when those discovery documents and interrogatories were due. When someone is served with discovery requests, they're allowed to object. After objections are raised, both sides are supposed to meet and confer to hash out disagreements before dragging it into court and asking the judge to step in. Speaking from experience, I've been through multiple lawsuits. Judges hate getting involved in motions to compel too early. They don't like sanctioning parties if it looks like both sides haven't tried hard enough to resolve things on their own. I once waited over 2 years to get discovery documents, and even then, I didn't get everything I needed. So when I see Leslie filing this motion just 2 weeks after the requests went out, I know exactly what's going on. This isn't just about getting documents. It's a strategy. Filing the motion lets her publicize exactly what she asked Justin for. It gives her an opening to discredit him, smear him, and accuse people like Melissa Nathan of wiretapping, just like they did earlier with Stephanie Jones. To me, this looks like two things. First, she's trying to get in front of the judge before he rules on the motion to dismiss that's still pending. She wants to plant the idea that, hey judge, look, they don't have any evidence. Please throw this out. Second, she wants to continue damaging Justin's reputation in the media. In the motion, Leslie's attorneys wrote, after 4 months of dissembling and issuing vague and inconsistent statements through their attorneys, the Wayfair parties have yet to identify the basis for their claims against the Sloane parties. Basically, they're claiming Justin's team hasn't been clear about exactly what Leslie supposedly said, to whom, or when, and that's just not true. That information is spelled out in their complaint. They even have text messages from a Daily Mail journalist who received direct tips from Leslie Sloane about what was happening on set. Those texts confirm Leslie was leaking information to the press. Leslie knows exactly what she did, so for her to act like she's clueless is ridiculous. This motion is just her way of reminding the judge, hey, remember I filed that motion to dismiss? Remember how strong it was? Remember how I argued they don't have evidence? She's hoping to nudge the judge into thinking she's in the right, even though the court hasn't ruled yet. By the way, Leslie, motions take time. I've been waiting 4 months on a motion for summary judgment in Minnesota. So sit tight, this is how litigation works. Leslie's filing also includes little footnotes, trying to slip in accusations. But if she really had solid claims, they wouldn't be buried in footnotes. They'd be front and center. One of her claims is that Melissa Nathan illegally listened to Leslie's phone calls, violating California's wiretapping laws. Leslie points to a Daily Mail reporter's message that says, I had a 3-way call with her and Melissa, and she never said anything about it then either. Leslie claims she never agreed to a 3-way call and that someone must have secretly added another person without her consent. But here's the thing, Leslie has known about that screenshot for months. The only reason she's bringing it up now is because there are active claims against Stephanie Jones for actually intercepting messages illegally. So this is pure deflection. They're trying to make it look like Melissa Nathan is the real wiretapper instead. And here's something else I need to say. Even though Leslie Sloane has her own team of attorneys handling this case, I have a strong feeling a lot of what's happening is being driven directly by Ryan Reynolds and Blake Lively themselves. It's clear they want to get out ahead of these wiretapping allegations and tell the judge, look, we didn't do this, they did. But that's not how it works. If Leslie really believed she had a legitimate claim here, she wouldn't just mention it in passing. She'd actually bring charges. Instead, in my opinion, she's throwing these accusations around just to slander people and hide behind litigation privilege. It's classic, you accused us? Well, fine. We'll accuse you back. Let's also remember that Leslie was directly involved in getting illegally obtained documents. Stephanie Jones wasn't supposed to hand over those private messages, but she did, and Leslie ended up with information she had no business having. Now, Leslie is just trying to deflect by pointing fingers at Melissa Nathan and acting like she's the one who did something wrong. Honestly, it's transparent, and I have a good feeling the judge will see right through it. In her motion, Leslie argues that the Wayfair parties should be forced to make admissions and stop hiding behind what she calls boilerplate objections to reasonable discovery requests. But here's the thing, those objections? They're standard. Every lawyer uses them in discovery. That's normal. What's ironic is that Leslie is complaining about boilerplate objections at the same time she and her team used a boilerplate lawsuit, a sham case, to illegally obtain private records from Jen Abel's phone. And Stephanie Jones is now being sued for some very serious charges: wiretapping, computer fraud, and violations of federal data storage laws. These aren't small claims. So, again, this tactic from Leslie? Classic PR playbook. Flip the script. Change the narrative. She also mentions interrogatory number 3, which asked them to identify every person Leslie communicated with regarding the Wayfair parties. They've already identified at least a couple of people. And honestly, the reason for this request is obvious. If you're claiming defamation and false light, you need to show who said what and to whom. The only way her argument makes sense is if they didn't have concrete evidence. But they do. They have text messages from the Daily Mail journalist showing exactly what Leslie said and shared. So once again, Leslie is just trying to convince the judge that there's no evidence, when in reality, she knows exactly who she talked to. I guarantee she has all those details in her own emails and records. She knows which journalists she spoke with, which outlets she tipped off, and exactly what she told them. Acting like she doesn't remember is ridiculous. She also objected to interrogatories 4, 5, and 7, claiming those objections are valid. Those interrogatories asked her to identify the specific stories that portrayed Baldoni as a sexual predator, both generally and ahead of the film's release. She argues they don't have to respond because the interrogatories are too broad. But then they say, okay, fine, if you think it's too broad, can we have permission to reserve and narrow them? The same courtesy Leslie previously refused to give to the Wayfair parties when they wanted to amend their filings. The hypocrisy is staggering. Now, Leslie is also asking the court to compel the Wayfair parties to produce documents for request for production number 32, which is basically asking them to hand over any documents they plan to use if they amend their complaint in the future, including documents referenced in their March 6, 2025 opposition brief. Leslie is saying that if they don't have any new evidence, they should just admit it. But here's the reality. The judge is almost certainly going to rule that her request is premature. If they haven't actually filed an amended complaint yet, they don't have to hand over any of that evidence. And they're definitely not going to give her their smoking gun before they're required to. All Leslie wants is to corner them into saying, okay, fine, we don't have anything new. But it's too early for that. This is just a desperate attempt to escape the lawsuit. What Leslie is essentially saying to the judge is, please, please, please grant my motion to dismiss. Please force them to show all their cards right now. And if I'm wrong about the scope of discovery, oops, my bad. Can you give me permission to fix my requests and try again? Now, let me show you just how hypocritical some of Leslie's own discovery requests are. Because when you look at what she's asking the Wayfair parties to produce, It's disgusting. And I want to make something really clear before I explain this next part. Leslie keeps insisting she never called Baldoni a sexual predator. She claims she never said he sexually assaulted anyone. Now, when they responded to her discovery requests, they did exactly what any competent legal team would do. They laid out standard objections. They objected based on admissibility, relevance, attorney-client privilege, and protecting documents they're under a legal obligation not to disclose to third parties. Right from the start, they made it clear they're not just handing everything over. One of their first broad objections was that Leslie's requests were irrelevant, overly broad, unduly burdensome, and disproportionate to what's actually needed in this case, especially when she was asking for information dating all the way back to January 1st, 2019. That's odd, because didn't the alleged smear campaign supposedly start in August 2020? And didn't the judge already rule that only information from August onward was even relevant? Why does she suddenly need documents from before any of this even started, before Blake Lively was ever remotely involved? Some of her demands were just absurd. For example, she asked for all documents concerning Leslie Sloane. Of course, they objected to that for multiple reasons. Same thing when she demanded all documents concerning Vision PR. But even with those objections, they still said they'd produce what they reasonably could, just not everything she asked for. Then there's the part that honestly crosses the line. She requested all documents related to allegations of sexually explicit, inappropriate, or unwelcome conduct or comments made by Baldoni, Heath, or anyone else during the film production, or anyone else at any time. What does that even mean? That's so vague, it's meaningless. Naturally, they objected, not only because it's vague, but because it could also force them to turn over documents protected by trade secrets, attorney-client privilege, and work product doctrine. Still, they said they'd hand over some documents, but not everything she asked for. Then she pushed even further, demanding all formal or informal complaints or discussions about the work environment on the set, including anything related to the Lively Reynolds parties. Again, they said they'd produce what they could, but objected where necessary. And here's where it gets wild. She asked for communications about complaints against Baldoni or Heath in any employment setting at any point in time. That's just insane. It's wildly overbroad. In my opinion, what she's doing here is crystal clear. She's angry that she got dragged into this lawsuit, and now she's lashing out through discovery. She's being petty and trying to bury them in paperwork. Pure spite. But it gets worse. She asked for all documents related to allegations of sexual harassment, sexual assault, or unwanted sexual contact by Baldoni or Heath at any point in time. Wait a second. Didn't she say she never accused Baldoni of being a sexual predator? And now she's demanding documents that he sexually harassed or assaulted people. Which one is it? He flatly refused to produce anything here, saying he has never sexually harassed anyone, so no, he's not going to go digging for documents that don't exist. Then it got even more ridiculous. She demanded all contracts or agreements with PR firms, marketing agencies, social media consultants, or any third-party services related to seeding, boosting, manipulating, or amplifying social media narratives, including bots. And at the end of the day, Baldoni's team responded that he didn't do any of this, so naturally, he can't provide documents that don't exist. She even asked for all documents related to actions taken to harm the Lively Reynolds parties, Sloane, or Vision PR, and damage their public image. Again, what does that even mean? It's so vague it borders on nonsense. And once more, Baldoni's team objected, saying clearly, he disputes that he took any such action, so he doesn't have documents to give. It didn't stop there. She asked if he had paid anyone to post negative material or comments. His answer, no, I didn't. I have nothing to hand over. She asked about bot services again and again, 5 separate interrogatories about bots, and every time, his team responded that he didn't use bots, didn't pay for bots, didn't hire anyone to manipulate social media. No documents because it didn't happen. She demanded all communications with any media outlet where he allegedly encouraged them to publish negative stories about the Lively parties, Sloane, or Vision PR. Again, he denied ever doing that and objected on the same grounds. Then she went as far as demanding all communications with cast, crew, colleagues, agents, or associates where he supposedly tried to gather negative intel on Blake and Ryan. His team flatly rejected that as well because, again, he says he didn't do that. She even asked if he drafted any articles about Blake or Ryan, which he also denied. Then she came back with another broad request. Any attempt to hide or divert attention away from Wayfair parties inappropriate or harassing activity on set or related to the film, all documents. Again, he objected and made it clear. He disputes that any inappropriate or harassing activity happened. There's nothing to hand over. This whole thing is just crazy. Honestly, this is what narcissists do. They throw out wild, baseless allegations and expect you to prove a negative. And here's the truth. You can't prove a negative. If you didn't do something, you don't have documents to show you didn't do it. And that's exactly what's happening here. And here's the thing. You wouldn't have documents to produce for any of this if you didn't do what she's accusing you of. For example, she asked for all documents about formal or informal complaints of a hostile work environment. He objected. She asked for all documents about any real or alleged feud, dispute, or disagreement between any of the Lively Reynolds parties and any of the Wayfair parties, whether it had to do with filming, editing, production, marketing, publicity, or distribution of the film. Again, he objected and made it clear he's not going to search for these documents because it would violate the privacy rights of third parties, and frankly, a lot of these documents aren't even in his possession or control to begin with. She then demanded any documents related to negative media or social media campaigns against the Lively Reynolds or Sloane parties. Now she's flipping the script, trying to argue that she's the victim of a smear campaign, even though, remember, she's not even suing him. Once again, Baldoni's team flatly disputed that he ever took part in any negative media or social media campaign against them. Then it gets more intrusive. She asked for all documents related to efforts to conceal strategies, and even all communications where Baldoni allegedly discussed his porn addiction with Lively. Wait, I thought she said she wasn't accusing him of sexual harassment or assault. Here, under oath, Baldoni responded clearly. He disputes that he ever discussed a porn addiction with Lively. That's the first time we're hearing from him directly, under oath, saying that conversation never happened. She also asked for all documents about him entering her trailer without her consent. Again, under oath. He stated flatly that he never entered her trailer without consent and will not be searching for documents on something that didn't happen. She wanted all documents about Baldoni improvising kissing or sexual scenes in the film. Again, he denied that this ever took place and refused to search for documents. And here's where it gets downright disgusting. She demanded all documents and communications concerning Baldoni having sexual conduct with a third party without Lively's consent. This is just an attempt to paint him as a predator, purely to humiliate him and slander him further. He strongly denied this as well, saying he never engaged in sexual conduct with a third party without her consent and would not be producing documents on baseless claims. And even if something like that existed, it doesn't. It wouldn't even be relevant to this case. She even went so far as to demand documents identifying people involved in text messages mentioned in paragraph 193 of the amended complaint. Baldoni's team said plainly that he does not have those documents in his possession. Finally, she asked for all documents that he intends to rely on when drafting a further amended complaint, including documents referenced in their March 6, 2025 brief in opposition. And here's the crux of it all. This is the real reason she filed the motion to compel. She's not pushing the court to force him to hand over documents about sexual assault, harassment, smear campaigns, bots, or any of those extreme accusations. She's not fighting about that. She's only asking the judge to step in when it comes to what evidence they have on her. All those obscene, invasive demands she made, and which Baldoni objected to, she's fine letting those objections stand. Oh, you didn't harass anyone? Cool. Oh, you didn't run a smear campaign? Great, I don't care. I just need to know what you have on me. That's what she's panicking about. That's why she's gone to the judge. She wants the court to compel an answer to request for production number 32. That's it. Because she's scared of what Wayfair has on her. Wayfair's team rightly argued that her request is overly broad, unduly burdensome, protected by attorney-client privilege and work product doctrine, and, importantly, premature, since they haven't even filed that amended complaint yet. They're not handing those documents over, period. She ran to the judge for one reason, and one reason only, because she is terrified about what they have on her. Everything else? She doesn't care. She's only trying to cover herself. And here's something else worth remembering. Leslie Sloane is still the PR agent for Ryan and Blake. So on one hand, she's saying, Baldoni, you're not a sexual predator. But on the other hand, she's demanding all these documents as if he is. And all of this comes on the heels of recent revelations: the illegal subpoena, the sham lawsuit, and the wiretapping. She's scrambling to deflect, to get something in the court docket purely for PR purposes, so she can turn around and say, see, he did it too. But the crazy part is, he didn't. Because she's not even accusing Baldoni of these things directly. She's accusing Melissa Nathan. And last time I checked, Melissa Nathan is not Justin Baldoni. I'm just getting more and more disgusted as this unfolds. It's painful watching someone get dragged through something like this, especially when you're up against narcissists and sociopaths who have no remorse and no regard for the truth. It's going to be a long road for Baldoni. And honestly, these interrogatories and document requests, they're not about facts. They're about harassment. They're about overwhelming him, fatiguing him, and hoping he'll drop the case. When she couldn't get the judge to dismiss it outright, she switched strategies, bog him down in paperwork. And this motion to compel is just another tactic in that game. Abuse the court, paint him in a bad light, and try to win in the court of public opinion. That's just my take. You're absolutely entitled to yours. Again, I'm not a lawyer, but I'd love to know what you think about all this. If you found this video helpful, give it a thumbs up, subscribe to the channel if you haven't already, and hit that notification bell so you don't miss anything. Thanks so much for watching. See you next time.